order in the court. Judge Anthony Tringer's voice thundered through the packed federal courtroom as he slammed his gavel down. The sound echoed off the mahogany walls as all eyes turned to the exchange unfolding before them. Judge Traynor leaned forward, his face flushed with barely contained anger. Ash pointed his finger directly at Congresswoman Jasmine Crockett. "I will not tolerate these theatrics in my courtroom, Congresswoman," he declared, each word dripping with condescension. For the past 10 minutes, he had been publicly dressing her down about proper courtroom procedure after she attempted to introduce new evidence in a high-profile civil rights case. The spectators watched in stunned disbelief as one of the most influential federal judges in Virginia continued his blistering attack on the Congresswoman. "Congresswoman, with all due respect to your position in my courtroom, the rules of evidence apply to everyone equally. Your attempt to introduce these documents at this late stage shows a core misunderstanding of federal court procedures," Judge Traynor said, his voice carrying an unmistakable tone of condescension. The gallery of spectators shifted uncomfortably. Several reporters exchanged glances, sensing they were witnessing something unprecedented. A federal judge publicly dressing down a sitting member of Congress who happened to be a former practicing attorney. What happened next left Judge Traynor visibly stunned and the entire legal community buzzing. Crockett calmly opened a leather portfolio that no one expected contained documents that would not only turn the case upside down but call into question Judge Tringer's entire legal career. If you're tired of seeing influential officials abuse their authority without consequences, you won't want to miss what comes next. Hit that like button and subscribe, because what Congresswoman Crockett did next didn't just win her case. It exposed legal misconduct that legal experts will be discussing for years to come. To understand why this courtroom exchange has sent shockwaves through America's legal system, we need to understand who these two figures are and why their clash represents far more than just a heated instance in court. Judge Anthony Traynor, 71, has served on the United States District Court for the Eastern District of Virginia since 2008, when he was appointed by President George W. Bush. With his Georgetown law degree and background at one of Virginia's most prestigious law firms, Traynor built a standing as a no-nonsense judge who ran a tight courtroom. Known for his conservative legal philosophy, Judge Traynor gained national attention when he presided over several high-profile national security cases. He's generally respected by the legal establishment, with a standing for being detailed about procedural rules and sometimes harsh on attorneys he feels are unprepared. Throughout his career, he has maintained close ties with business interests and conservative legal organizations, frequently speaking at their events. The case where this exchange occurred involved allegations of civil rights violations by a major corporation against minority employees. The plaintiffs claimed systematic discrimination in hiring, promotion, and workplace treatment, with damaging evidence that had survived multiple attempts by corporate defense attorneys to have the case dismissed. Judge Traynor had shown increasing skepticism toward the plaintiffs' claims in recent hearings, issuing several rulings that limited the scope of evidence they could present. Legal observers had begun to question whether his handling of the case showed implicit bias, though few would say so publicly about a sitting federal judge. Congresswoman Jasmine Crockett brought a dramatically different background to this exchange. Now in her second term representing Texas, Crockett had established herself as one of the most formidable former attorneys ever to serve in Congress. Before winning her SEAT, she had built an impressive 15-year career as a civil rights attorney and criminal defense lawyer. A graduate of the University of Houston Law Center, Crockett earned recognition for her work demanding corporated discrimination and representing communities whose civil rights had been violated. She was known for her detailed preparation and innovative legal strategies that often caught opposing counsel off guard. What wasn't widely known before this hearing was that Crockett had maintained her legal credentials and occasionally represented clients in civil rights matters of particular significance, including this case where she had recently joined the legal team representing the plaintiffs. The stage for exchange was set when Crockett's legal team sought to introduce newly discovered evidence showing a pattern of discriminatory practices across multiple corporate locations. Judge Traynor had initially rejected their motion, citing procedural timing. This ruling threatened to derail the entire case as the evidence was crucial to establishing the systematic nature of the discrimination. When Crockett rose to address the court that morning, observers expected routine arguments about admissibility. None anticipated that she had spent the previous 3 weeks conducting an independent investigation that would uncover not just evidence relevant to the case, but information about Judge Traynor himself that would forever change his legal legacy. If you're finding this breakdown valuable, take instance to hit that like button and subscribe to our channel. We bring you these detailed analyses of pivotal moments in our justice system that mainstream media often overlooks. Your support helps us continue this important work. The United States District Court for the Eastern District of Virginia was unusually crowded that Thursday morning. Extra chairs had been brought in to accommodate the overflow of spectators, many of them law students from nearby universities who had heard that Congresswoman Crockett would be presenting arguments. The room had the formal, hushed atmosphere typical of federal courts: mahogany benches, the seal of justice prominently displayed, and the elevated bench where Judge Traynor presided. When the bailiff called the court to order, Judge Traynor entered wearing his black robe, his expression stern as he surveyed the packed gallery. "We're here to address the plaintiff's motion to reconsider the ruling on newly discovered evidence," Judge Traynor began, his tone already signaling his skepticism. "Though I must say, I find it unusual that Congresswoman Crockett has chosen to personally argue this motion rather than leaving it to lead counsel." "Thank you, Your Honor," Crockett responded, rising from the plaintiff's table. She wore a tailored navy suit, her demeanor calm and professional. "I appreciate the court's time in reconsidering this crucial matter." For the next 10 minutes, Crockett methodically outlined the legal basis for admitting the new evidence, citing federal rules of civil procedure and relevant case law with notable precision. Those in the gallery familiar with legal proceedings could tell she wasn't relying on notes. She was citing case numbers, dates, and specific legal tests from memory. Judge Traynor interrupted frequently, his questions becoming increasingly pointed. "Congresswoman, I'm familiar with the Foreman decision, but it doesn't apply here because your team had ample opportunity to discover this evidence during the normal discovery period. The rules exist for a reason. We can't have parties introducing new evidence at every stage of litigation." "With respect, Your Honor," Crockett countered, "the Form decision specifically addresses situations where evidence was deliberately withheld by the opposing party, which is precisely what happened here." She opened a folder and approached the bench. "If I may, this email thread shows defense counsel was aware of these documents 8 months ago and failed to produce them despite our specific discovery request." Judge Traynor reviewed the emails, his expression darkening. "This is troubling, but it doesn't change the fact that your motion comes after the deadline established in our scheduling order. That's why the Rodriguez standard applies, Your Honor." Crockett responded without hesitation. "When discovery violations are only uncovered after a deadline has passed, the court has discretion to modify its scheduling order in the interest of justice." The gallery could sense Judge Traynor's growing frustration. Legal professionals present acknowledged that Crockett's command of procedural rules was exceptional. She was effectively boxing the judge in with his own previous rulings and established precedent. "Congresswoman Crockett," Judge Traynor said, his voice taking on a dismissive tone, "while your advocacy is commendable, I think you may be out of your depth in federal court procedure. This isn't a congressional hearing where rules can be bent for intense effect. My courtroom operates on strict adherence to procedural rules developed over centuries of jurisprudence." The condescension was unmistakable, and a murmur ran through the courtroom. Several of the law students looked uncomfortable, recognizing the inappropriateness of the judge's tone. Crockett remained composed, though those closest to her noticed her straighten her postures lightly. "Your Honor," she replied evenly, "before serving in Congress, I litigated over 100 federal cases, including 8 that reached the Fifth Circuit. I'm intimately familiar with federal court procedures, and with all due respect, the rule you're citing doesn't say what you claim it does." The room grew completely silent. Demanding a federal judge so directly was almost unheard of, even among experienced attorneys. Judge Traynor's face flushed slightly. "Enlighten me then, Congresswoman," he said, the sarcasm evident in his voice. "Gladly, Your Honor." Crockett approached the bench again, this time carrying a different folder. "Federal Rule of Civil Procedure 60B2 specifically allows for a consideration based on newly discovered evidence that with reasonable diligence could not have been discovered earlier. The key phrase is reasonable diligence, which your own ruling in United States v. Davidson defined as efforts that are suitable to the circumstances and constraints faced by the party." She placed a copy of Judge Traynor's own ruling in Davidson on the bench. "You wrote this opinion just last year." "Your Honor, our team exercised reasonable diligence. But the defendants deliberately concealed these documents, as the emails I just showed you prove. Judge Traynor scanned his own words, visibly unsettled by having his ruling turned against him. The gallery watched as he shifted in his seat, clearly reconsidering his method. Even if I were to accept that argument, Congresswoman, the evidence must be material to the case at hand. These additional employee complaints from other states don't establish a pattern relevant to our plaintiffs here in Virginia. This was the opening Crockett had been waiting for. On materiality, Your Honor, I'd like to introduce one final document that establishes the direct relevance of these complaints. She retrieved a third folder from Hurtable. This is an internal memo from the defendant corporation's HR director to their general counsel, dated January 12th of last year. As she handed the document to the judge, she continued, "It explicitly discusses the need to handle complaints consistently across all states to avoid creating a paper trail that could establish a national pattern of discrimination. This memo references complaints from all 7 states, where similar issues were raised, including the specific complaints of our plaintiffs." Judge Traynor reviewed the document, his expression growing increasingly troubled. "Where did you obtain this memo, Congresswoman?" "It wasn't included in your motion. It came into our possession yesterday evening, Your Honor. A whistleblower from the company's legal department contacted us after learning that you had denied our original motion." Crockett paused before continuing. "The whistleblower was concerned because the company's attorneys had specifically mentioned to colleagues that they expected a favorable ruling from you on this matter before you had even heard our arguments." The courtroom erupted in whispers. Judge Traynor banged his gavel sharply. "Order. I will not have such insinuations in my courtroom. Congresswoman, that borders on contempt. I'm not making insinuations, Your Honor. I'm stating facts supported by evidence." Crockett returned to her table and retrieved a final folder. And that brings me to the most troubling document of all. The tension in the courtroom was palpable as Crockett approached the bench with her final piece of evidence. Defense attorneys shifted nervously in their seats while spectators leaned forward, sensing a pivotal instance. "Your Honor, this document came to us through the same whistleblower," Crockett said, her voice steady and clear. "It's an email exchange between the lead defense counsel and the company's CEO, discussing their litigation strategy." She handed the document to the clerk, who passed it to Judge Traynor. As he began reading, his face visibly palled. The email specifically mentions, and I quote, "Judge Traynor has been a reliable ally in these matters since his appointment. His former law firm still represents our subsidiaries in 3 states, and his financial disclosures show he maintains investments in our parent company. How can be counted on to exclude the cross-state evidence on procedural grounds?" The courtroom fell completely silent. The implications were staggering, suggesting both a conflict of interest and potential legal misconduct. Judge Traynor's hands trembled slightly as he placed the document down. "Congresswoman, these are serious allegations that have nothing to do with the admissibility of your evidence." "With respect, Your Honor, they have everything to do with it," Crockett replied firmly. "Federal law requires legal recusal when a judge has any financial interest, however small, in the subject matter of the case or in a party to the proceeding. Your financial disclosures, which are public records, show investments in Transcorp Holdings, the parent company of the defendant." She produced copies of Judge Traynor's own financial disclosure forms filed with the Administrative Office of the U.S. Courts. Additionally, 28 U.S.C. Section 455A requires recusal in any proceeding where your impartiality might reasonably be questioned. The fact that your former law firm currently represents the defendant's subsidiaries creates precisely such a situation. The defense attorneys jumped to their feet. "Your Honor, we object to this ambush. This has nothing to do with the motion before the court." On the contrary, Crockett responded before Judge Traynor could speak. "It has everything to do with it. The legal standard for reconsideration includes whether justice requires revisiting a prior ruling. When that ruling was made by a judge who failed to disclose conflicts of interest, justice absolutely requires reconsideration, not just of this motion, but of every ruling in this case." Judge Traynor sat stunned, the confidence and condescension completely gone from his demeanor. The courtroom remained deathly steady as he peered to weigh his options. After what seemed like an eternity, he spoke. "This court will take a 30-minute recess. I need to consult with the chief judge regarding these matters." He rose abruptly and exited to his chambers. During the recess, the courtroom buzzed with shocked conversations. Law students were frantically taking notes while reporters rushed to file initial stories. Several attorneys in the gallery could be overheard saying they'd never witnessed anything like this in decades of practice. When Judge Traynor returned, his face was grave. Beside him was Chief Judge Rebecca Hollis of the Eastern District of Virginia, a highly respected jurist known for her commitment to legal ethics. In light of the serious matters raised, Judge Traynor began, his voice subdued. "I am recusing myself from this case strong immediately. Chief Judge Hollis will address the court." Judge Hollis stepped forward. "This court takes allegations of legal misconduct and conflicts of interest with the utmost seriousness. I will personally review all evidence presented today and have already contacted the legal counsel of the Fourth Circuit regarding an ethics investigation." She turned to Crockett. "Congresswoman, your motion to admit the new evidence is granted. Furthermore, I am ordering a complete review of all previous rulings in this case. This matter will be reassigned to Judge Williams, who has no connections to any of the parties involved." As Crockett gathered her papers, the implications of her victory were clear to everyone present. What had begun as a routine procedural motion had exposed serious ethical breaches that would forever change Judge Trenga's career and potentially affect dozens of his past rulings. Outside the courtroom, as reporters surrounded her, Crockett remained controlled and professional. This case was never about a personal exchange. It was about guaranteeing that our legal system works fairly for everyone, regardless of their wealth or connections. When the rules are applied equally, justice prevails. The aftermath of the Crockett-Trent exchange was immediate and far-reaching. By that evening, the story had broken in every major news outlet. The Washington Post ran with a headline, "Congresswoman exposes federal judges' undisclosed conflicts in intense courtroom showdown." CNN featured a panel of legal experts discussing the implications for legal ethics nationwide. Within 48 hours, the legal counsel of the Fourth Circuit announced a formal investigation into Judge Trenga's financial disclosures and potential conflicts in dozens of cases he had presided over during the past 5 years. The U.S. House Judiciary Committee, citing Crockett's findings, launched a parallel investigation into broader patterns of undisclosed conflicts among federal judges. For Judge Tra, the consequences were swift and severe. He announced a leave of absence, pending the investigations, and court records showed he had begun the process of recusing himself from all cases involving corporations with any connection to his investments or former law firm, a list that grew to over 30 active cases. Legal scholars across the partisan spectrum weighed in on the significance of what had occurred. Harvard law professor Lawrence Friedman wrote in a widely shared oped, "What Congresswoman Crockett accomplished goes outside a single case of victory. She exposed a vulnerability in our system of legal ethics enforcement that has allowed conflicts to remain hidden in plain sight." Conservative legal commentator and former federal judge William Pryor acknowledged on Fox News, "While I often disagree with Representative Crockett's politics, her actions in that courtroom represented the highest traditions of legal advocacy. The rules on legal conflicts exist for a reason, and they must be enforced regardless of which partisan party appointed the judge." The whistleblower who had provided the crucial documents came forward 2 weeks later, identified as Melissa Chen, a paralegal in the defendant corporation's legal department. In interviews, she explained her decision. "When I saw how the company's lawyers were boasting about their influence over Judge Tra, I knew I couldn't stay silent. This wasn't about politics. It was about right and wrong. For the plaintiffs in the original discrimination case, the impact was transformative. Under Judge Williams, the new evidence was fully admitted, creating a comprehensive picture of systematic discrimination. Within 3 months, the corporation agreed to a historic $175 million settlement and devoted to court-monitor changes in hiring and promotion practices across all its operations. The precedent-setting aspect of Crockett's courtroom victory extended far outside a single case. The Administrative Office of Use Courts announced new, more stringent requirements for legal financial disclosures and conflict checks. Several legal conferences added special sessions on ethics compliance with particular attention to investment conflicts. Law schools across the country incorporated the Crockett-Trent exchange into their legal ethics curricula. Georgetown Law created a special seminar titled Advocacy and Ethics, When Demanding Legal Conduct is Necessary. The American Bar Association updated its guidelines on attorney responsibilities when facing potential legal conflicts of interest. For Congresswoman Crockett herself, the incident fundamentally changed her national profile. Though she'd always been respected for her legal acumen, she now became acknowledged as one of the foremost legal minds in Congress. Law students and young attorneys, particularly women of color, cited her as an inspiration for combining public service with unwavering ethical advocacy. Perhaps most significantly, the case sparked a national conversation about accountability in the judiciary. A Gallup poll conducted 1 month after the incident showed that 83% of Americans believed federal judges should face stricter ethics requirements and greater transparency in their financial holdings. 6 months later, bipartisan legislation called the Legal Financial Transparency Act was introduced in Congress, requiring more comprehensive disclosures and establishing an independent review board for legal ethics. When introducing the bill, the Republican co-sponsor specifically cited Crockett's courtroom exchange as a wake-up call that transcends partisan differences. The corporate legal community also felt the ripple effects. The Association of Corporate Counsel issued new guidelines warning against any communications suggesting improper influence over judges or expectations of favorable treatment. Several major law firms conducted internal reviews of their litigation communications to ensure compliance with ethical standards. 1 year after the exchange, a comprehensive study by the Brookings Institution examined its impact on legal ethics enforcement. The report concluded, the Crockett-Trenga incident represents a watershed instance in legal accountability. By exposing how conflicts of interest can distort legal decision-making, it has strengthened public confidence that such conflicts will be identified and addressed. As for Judge Traynor, the final chapter of his legal career was written when the Fourth Circuit Legal Counsel completed its investigation. The counsel found that he had failed to disclose conflicts in 37 cases over a 7-year period. Rather than face potential impeachment proceedings, Judge Traynor announced his retirement from the federal bench. In his retirement statement, he acknowledged errors in judgment. While I have always strived to uphold the highest standards of legal conduct, I recognize that my failure to properly disclose certain financial interests has undermined public confidence. Our justice system depends on such confidence, and I regret any damage my oversights may have caused. The lasting legacy of the exchange was perhaps best captured by a first-year law student who had been present in the courtroom that day. In an essay that went viral on social media, she wrote, "What I witnessed wasn't just a legal argument. It was a masterclass in moral courage. Congresswoman Crockett showed me that being a great lawyer isn't just about knowing the law. It's about having the courage to ensure the law works equally for everyone, even when that means demanding the most influential figures in our justice system." For millions of Americans who had grown cynical about accountability for those in positions of power, the Crockett exchange provided a rare and inspiring counterexample. Proof that preparation, courage, and adherence to principle could still overcome entrenched privilege and restore faith in the possibility of equal justice. If this story of legal expertise and ethical courage inspired you, hit that like button and subscribe for more content that shows how knowledge and determination can speak truth to power. Share your thoughts in the comments about which instance in this exchange you found most influential. Because when we hold our institutions accountable to their highest values, we all become stronger citizens in our democracy.